NACDL is the association of the nation's criminal defense bar.
Thank you everyone for joining us for the second panel of day 2. If you're just joining us, if this is your first session of the conference, my name is Reid. I have the pleasure of serving as the Director of Advocacy here at the National Association of Criminal Defense Lawyers. I am definitely very excited to bring you this panel discussion at the State Criminal Justice Network Conference. This will be a panel discussion targeting Marsy's Law. And as a kind of a side plug, this issue came to us and was brought to our attention actually by one of our state affiliates, the Kentucky Association of Criminal Defense Lawyers, a few years ago. And this is a testament to why, especially if you are a state affiliate, again, this is kind of like a side plug, to communicate and to stay in communication with us at NACDL regarding your state priorities or your state legislative priorities in terms of what's going on in your legislature. We have a great relationship with our Kentucky affiliate. And so when this came up, they were like, hey, we're dealing with this in our state. Have you seen it in other states? Can you help us? And then we have been kind of involved ever since then. I think that was probably in 2017. So definitely, you know, for affiliates, stay in contact and let us know what you're dealing with as relates to your state legislative advocacy. So I'm definitely pleased to bring to you several advocates who have been dealing with Marsy's Law in their respective states. And just a little bit of background for those who have dealt with Marsy's Law in their state. I'm sure you already know all this information, but for those who you may not have dealt with it yet, I just want to say, you know, just be on the lookout, definitely so, and you'll find out why throughout the duration of this panel. But for some background, so Marsy's Law is a victims' rights constitutional amendment. It would bestow upon crime victims and alleged crime victims a vast array of what is often vague and difficult and costly to administer rights. This includes extensive notification, involvement, privacy, restitution provisions, and would enshrine them into the state constitution. The versions that have been adopted in states may vary. The model would basically enshrine about 15 rights upon crime victims. One in particular, just to highlight, is the right to refuse an interview, deposition, or other discovery request that's made by the accused or someone acting on behalf of the accused as well. It would also, again, the model would also expand the definition of victim. It would include both the person directly harmed by the crime or any spouse, parent, grandparent, child, sibling, grandchild, or guardian, and any person with a relationship to the victim that is similar to what was listed as well would be included under the definition of victim in the model. Again, the versions that have been adopted by the states that have it may vary, but this is what is included in the model amendment. So indeed, Marsy's Law, the movement to pass Marsy's Law seeks to ensure that victims of crime have equal constitutional rights on the same level of those accused and convicted of crimes. And you'll hear them often posing the question of why should defendants have more rights than that of crime victims. And the fallacy of this argument, one that we will discuss throughout this panel, is the fact that defendants' rights are rights against the state, while rights set forth in Marsy's Law are rights against another individual. And it's largely at a time when that individual is presumed innocent. So we are going to be unpacking the impact of Marsy's Law on those states that have adopted this model. In the beginning, you may have thought that the concerns raised by the defense bar and other opponents have been somewhat anecdotal, but that is just no longer the case. Serious concerns and problems as it relates to Marsy's Law are popping up all over the country in states that have adopted this model. The notice provisions have been causing delays in proceedings, especially in bail hearings, where defendants are often forced to sit in jail for extended periods of time while prosecutors attempt to fulfill the law's notification requirements. States are struggling to balance the privacy provisions in Marsy's Law and the public's right to know. And there have been several instances in where police officers have actually invoked the privacy protections under Marsy's Law, shielding their names from public release and accountability as well. There's one incident where an Ohio City recently claimed it was entitled to financial restitution as a victim under the state's Marsy's law for a false 911 call. We have about a dozen or so states that have adopted this model. Kentucky is dealing with it, and I won't take the thunder of our panelists, but Kentucky is still dealing with it, and there's some litigation that's going on in several states as well. So I'm going to start off with our first panelist, which is Jerry Booting. He is the partner in a Brookfield, Wisconsin law firm of Booting, Williams, and Stilling. He is a past board of directors member of the National Association of Criminal Defense Lawyers, and he is the recipient of the 2017 National Champion of Justice Legal Award, and a past president of the Wisconsin Association of Criminal Defense Lawyers. So I'm turn it over to Jerry just to talk more in-depthly about Marsy's law impact on the defense and those accused of a crime, and tell us what is the status of Marsy's law in Wisconsin.
Thank you, Monica. You know, we could do an entire day on Marsy's law, frankly, with all the details and the specifics in how it's being applied and misapplied in states that have passed it. Now, in Wisconsin, the amendment just passed in this spring, and so we're still dealing with a few examples, but it's being litigated and it's still early. Jackson can talk about more of the details in North Dakota where they've had it longer. But I want to talk about really three broad areas where I think it impacts the practice of a defense attorney who's trying to defend the accused. And the first Monica's alluded to, which is the presumption of innocence. Every defense lawyer knows that it is very difficult to get jurors to apply the presumption of innocence in a trial. And why is that? Well, there are a lot of reasons. One is certainly our culture, where the media, television, and movies over and over and over portray defendants as guilty. And Marsy's law really exacerbates that problem. How? Well, first, because victims are identified and labeled as such at the outset of proceedings, before a judge or jury has concluded that they are victims. In many cases, the very central issue at a trial is whether any crime occurred, and therefore whether the accuser is really a victim at all. Think about a sexual assault case where consent is the defense, or a homicide or battery where self-defense is the issue. The jury may conclude that there was no crime because the accuser was consenting in the instance of a sexual assault, or the defendant was exercising reasonable self-defense force in a violent offense. So in Wisconsin, the constitutional provisions quote, shall vest at the time of victimization. Now, what exactly does that mean? There are some arguments that could be made that still requires a judge or jury to find them victims before they are actually considered victimized. But I think that's going to be a tough sell because there are many rights. There's 16 different rights actually in the Wisconsin Amendment that include pretrial rights, right to be heard. So it's likely that the courts are going to say that this applies right at the outset before, in fact, we know whether the accuser is really a victim or not. And it also, Monica alluded how it expands the definition of victims in Wisconsin to include even anybody living with the decedent in a death case. So like housemates, not even relatives. But it also excludes as a victim anybody who, quote, does not act in the best interest of a victim, close quote. Now, Wisconsin courts are being told in the memorandums that went around that may apply in a common situation where a spouse, often the mother, let's say in a child sex abuse case, doesn't believe her child and sides with the defendant. Under the Constitution, the court could find that she doesn't have any standing as a victim and increase the pressure on her or him, if it's, whoever the spouse is, to isolate the defendant even further and make it more difficult to defend. So at its most basic level, Marsy's law really represents a fundamental misunderstanding of why a defendant has constitutional rights. As Monica alluded, it's to protect the accused against government power, to protect innocent people from being arrested, imprisoned, or in some states even executed. Whereas victims are not in an adversary position with the government and thus do not have the same needs for the constitutional rights or for rights to be enshrined in the Constitution, which in Wisconsin, the language is that they shall be enforced no less vigorously than a defendant's, which in my view and the view of many contradicts presumption of innocence. Second main area is in the issue of pretrial release. A defendant in every state has, under varying conditions, has a right to be released on bail. There are a few exceptions, but they are certainly few. The ability of a defendant to aid in his defense is made much more difficult if they are incarcerated pre-trial. It also unfairly affects the victims' families. People held in jail for any significant length of time on pre-trial lose their jobs, potentially could lose their residence, can't go to school, and all of these things happen to people who are presumed innocent. Even if the defendant is not actually innocent, it still impacts the outcome of the case. Study after study shows that defendants who are in custody at the time of sentencing are punished more severely than those who are out on bail. There's lots of reasons, because when you're out on bail, you can get treatment, you can demonstrate by complying with the conditions of bail, demonstrate to the court that you have learned a lesson, you've made lifestyle choice changes to try and, when it gets to the time of sentencing, so that the judge can conclude maybe that you're not a risk to the public and you can be treated and supervised in the community, or at least perhaps mitigating the length of sentence. So how does Marsy's law make this more difficult? Well, the courts are required to ensure that an alleged victim has advance notice of any, in Wisconsin's amendment, quote, proceeding, and the opportunity to be heard. Now that changed prior law in Wisconsin, which gave them notice and a right to be heard for any, quote, court proceeding. They've removed the word court and now it's any proceeding. And so that may mean scheduling conferences, in-camera proceedings, anything done off the record could be considered a proceeding. And that includes what are known as riverside hearings, where before a defendant ever makes his first appearance in court, a commissioner or judge reviews some materials, makes a determination of whether there's probable cause, and sometimes can set bail, which could be days before the defendant actually appears in court. That may not happen right now. We've already seen judges in Wisconsin that say they're not going to set bail even at initial appearances unless the prosecution can establish that the victim was given notice and an opportunity to be present and be heard. Such delays prolong incarceration and can result in all those collateral consequences we talked about. And by the way, this movement runs counter to the efforts to reform the whole cash bail system, which was discussed in yesterday's program, I believe. It's going to make it more difficult for a defense attorney to get reasonable bail, if opposed in court by both a prosecutor and a alleged victim who can also have counsel. Once again, it turns the presumption of innocence on its head by just assuming that the accuser who's presenting themselves in court is truthful, and therefore the judge should set high bail or whatever. Finally, then the third main area that I think it affects is the whole idea of access to information. And I think this probably has the biggest impact on a defense attorney who's trying to defend the accused. The amendment gives victims a, quote, right to privacy and the right to refuse a deposition or an investigation request. This makes it harder for the innocent accused to show that the accusation is fabricated and perhaps even the motive for doing so. And importantly, it denies or deprives the jury of what's often the best evidence in a case. For example, these days, young people often have a contemporaneous, real-time record of their communications, their thoughts, their intent. They text nearly everything. And in a sexual assault case, for instance, communications between the alleged victim and the accused may prove to contradict the accuser's claim to the police later, or in court. It could show inconsistencies in their behavior, or even prove outright lies in the accusation. And yet, alleged victims can assert their constitutional right to privacy to prevent even the police from having access to look at their phones, the times of their calls, text messages, or images at or near the time of the alleged offense. And by the way, as a quick aside, this runs counter to a movement in the UK, which recently changed their laws after some very high-profile cases where it came out in mid-trial that the accused's text directly contradicted their story and their testimony in court. In the UK, there is now, it's interesting what they've done, a Miranda-type warning that police read to the person, the complainant, that says that they should allow the police to have limited opportunity to review certain relevant parts of their phones, but they still have a right to refuse, but they're given notice that that decision might impact the prosecutor's decision on whether to proceed. So, back to Marsy's law, we've talked about, Monica mentioned how police are now trying to use it to deny open records request in officer-involved shootings. One can imagine an alleged victim saying that they should not have their prior conviction records released, or prior bad acts, perhaps, or in a self-defense case, that any episodes of prior violence should not be delved into and couldn't be used. We've seen protective orders being demanded now for all kinds of discovery in all cases, not just specific types. Motions to seal. This is kind of the one of the newest things, where prosecutors are arguing that the defense motion to introduce other acts involving the accuser should be sealed because it could sully their reputation. It could be used to cyberbully them. And ironically, of course, the prosecutors issued often graphic criminal complaints against the accused, sullying their reputation, and hand those out to the media. And these are the people who are supposedly presumed innocent. So one other thing now, the amendments, the model and Wisconsin's and advocates argue, though, well, this isn't intended to contradict, and that is overrule a defendant's constitutional rights. But in Wisconsin, the amendment actually says federal constitutional rights. They essentially wrote out any state-based constitutional rights of a defendant as being subordinated to any victim's rights. And it's also important, many people may not understand that if you're not a criminal defense attorney, that the United States Constitution has not been interpreted by the Supreme Court to guarantee a defendant any pretrial discovery. They will not enshrine discovery as a constitutional right. They talk about the right to present a defense that is a constitutional right, but it is really only the statutes in this country that provide for pretrial discovery. And those could easily be subordinated then to victim rights amendments. So I'm going to wrap up here just with a quick update, though. In Wisconsin, it passed, but it is being challenged. Every state's a little different in this regard. In Wisconsin, a constitutional amendment has to pass two successive legislation sessions in order to be on the ballot, where the voters can then decide whether to amend the Constitution. But there are requirements that the ballot question must be fair, complete, not misleading, and that it shouldn't include multiple rights. There should be individual questions if they're individual rights. So we've sued. I'm a plaintiff. We have an election lawyer as an expert who is handling the litigation. But it has been briefed. It was orally argued last week. The judge has asked for some additional briefing on whether or not certain parts of it could be severed if he found that it was improperly presented on the ballot. And so it's probably a couple of weeks away yet, a couple of months away before we know whether it will succeed, the challenge will succeed in Wisconsin. So my closing advice is, we waited too late in Wisconsin to challenge this. You know, Iowa did a much better job. Other states have done a much better job of presenting it early to the public. Once it gets on a ballot, the Marsy's law backers are, funded by a billionaire who, they use Kelsey Grammer in television ads with emotional appeals. And it's very, very difficult if you wait that long. So those of you in states where it hasn't happened yet, if you want to try and avoid it, try and start educating the public early.
Thank you so much, Jerry. And thank you for connecting the dots on how it will impact other reforms. I think that is very, very important because, like you said, its impact is undermining, efforts to reform cash bail systems. It's undermining efforts at discovery reform. And even now where we see this national movement and a lot of momentum around policing and accountability, well, those in states with Marsy's law will slide under those accountability because they are claiming victim status under the Marsy's law. So thank you so much for making that connection. And I just wanted to emphasize that because, it's a difficult messaging topic. We see a lot in states where it is the defense bar and their state ACLU who is on the opposing side, and that may be it. And so I really want to pique the interest of those who are tuning in to, even if if this is your first time ever hearing of Marsy's law, if you're working on bail reform, if you're working on policing, this will impact you if it comes to your state. And obviously, if it's in your state, it's probably already impacting you. I don't know if Nellie's still participating, but I know she's from Florida, and if she wants to share any horror stories in the chat, I'm sure people will appreciate that as well. So I'm going to move to the next panelist, and it's Jackson Lofgren from North Dakota. And Jackson, he is actually a past president of the North Dakota Association of Criminal Defense Lawyers and a partner with Suhr and Lofgren law firm in Bismarck, North Dakota. And Jackson was a part. North Dakota has been dealing with Marsy's law for a number of years now. So you guys adopted it a few years ago. So I want Jackson to just kind of talk about how it's been impacting the ability to represent his clients in the defense in North Dakota since the adoption of it in North Dakota. So thank you, Jackson.
Thank you, Monica. We've had Marsy's law in North Dakota since 2016. It passed here in North Dakota the same year that it passed in South Dakota. Both states obviously are very small in population, and both states were in a perfect position for the Marsy's law people to use the initiative process to get Marsy's law on the ballot with bypassing the legislature completely. And once it was on the ballot, it was very tough for us to mount any meaningful challenge to it. We got every major newspaper in the state to say this was a bad idea. We got politicians to say it was a bad idea. And at the end of the day, it was almost impossible to beat. We raised roughly $20,000 to fight Marsy's law. Marsy's law, the pro-Marsy's law people had one backer, and in North Dakota, he spent $2.3 million. So he outspent us 100 to 1. And every time you turned on the TV or the radio, it was Marsy's law, Marsy's law, Marsy's law. You'd have Kelsey Grammer reading a script, and it was identical whether it was in North Dakota or South Dakota. He would just change, what the amendment number was, depending on what state. And it passed almost 2 to 1. So it passes in the November election in 2016, and a few days later, we had a meeting with some of the stakeholders, I guess, in our criminal justice system, law enforcement, the attorney general, defense attorneys. And it was clear that for a lot of the law enforcement folks, they had never really thought about what does this mean. When I was describing to them that Marsy's law says that pretty much anybody who suffers a pecuniary loss could be a victim, and you've got to give all these people these cards, their response was, we're not going to do that. And the court system essentially had the same response. We're not going to hold up court hearings. They can get the Marsy's card, and if they want to show up, they can show up, but that's all we're going to do with it. Since Marsy's law has been on the books in North Dakota, it's not been a good experience for the defense bar or our clients. There's just massive confusion about what it means. If you look at the provisions of Marsy's law, they're very vague and open-ended. For example, what does the right of privacy really mean for the victim? And what you will commonly see is prosecutors' offices who want to be difficult will use Marsy's law to be difficult. You will request discovery, and you will get police reports that are completely redacted. It'll say, blank was walking down the street with blank. The defendant came and punched blank. There won't be any information in the police report that is usable to you at all. And they'll force you to file a motion to compel and require you to get a court order to get discovery that's of any use to you. In other counties and in other jurisdictions, they've gone so far as to almost take on an aspect like you might see in federal court, where before they will give you discovery, they make you sign a stipulation agreeing that you'll do all these things and force the court to sign off on it before they'll give you discovery. So because of that, it's had a real impact on some cases what information we're allowed to have. Another major impact it's had is prior to Marsy's law, we had in our state rules of criminal procedure the ability to depose people. And if your jurisdiction allows you to do depositions, I would encourage anybody, if the case requires it, to do it. They can be phenomenally helpful. You can find out things that the officers never thought to ask. People will provide information that completely changes the dynamic of the case. And we did not do them often in North Dakota, but in the right cases we would. And they were set up in a way that was very pro witness. They had to be conducted at the courthouse. The court could set limits on how long, how many questions you had to ask. If it was a child, the court could say the defendant can't be there. The child can elect somebody to come with them. Marsy's law changed all that. So anytime now that we want to do depositions, what will commonly happen is you'll do your notice of a deposition, you'll issue your subpoena, and a few days later you'll get a filing from the state's attorney's office saying that they've consulted with the victim and the victim's going to elect Marsy's law and not appear at the deposition. So for the most part, Marsy's law has completely ended our ability to do depositions in certain cases. Another area where Marsy's law has not been good to us, prior to Marsy's law, our state statute said in determining restitution, the courts should consider the defendant's ability to pay. Our Supreme Court has said Marsy's law got rid of that. So if you have a homeless person who happens to, maybe they're warming themselves up in a building and they start the building on fire and there's $3,000 in damages, our courts have said, well, Marsy's law took away the ability to consider the victim's ability or the defendant's ability to pay. So now you have to order whatever the maximum amount of restitution is. And if you think about that, if you order restitution that's unpayable as a condition of probation, how does that defendant get off of probation? How do they get out of the system? And it's really unclear as to how that is going to play out. Another thing that we've had to deal with is, as Monica mentioned, the use of Marsy's law to hide information related to police officers. We've had, since Marsy's law passed in North Dakota, a number of police-involved shootings where the law enforcement agency will issue a statement that the police officer is electing Marsy's law and they won't release any information about the police officer involved. So thinking about that, let's say you have a case where maybe your client's charged with resisting arrest or assaulting a police officer, and 2 weeks later, that same officer happens to shoot somebody. That would be information I'd want to know. But they will use Marsy's law to hide that. They'll say that under Marsy's law, the officer's a victim and you can't have that information. Some prosecutors are confused by Marsy's law. They think Marsy's law has changed the dynamic of the prosecution being the state versus the defendant. So if the victim doesn't want the charge reduced, or the victim says, I want this for a sentence, some prosecutors are afraid to go against that. They take the position that the victim gets to pick what the charge is and the victim gets to pick what sentence the state is going to recommend, which is extremely difficult to deal with. But as I said, Marsy's law, when prosecutors want to be difficult, they use it. When the victim comes in and says, I don't want this case to go forward, then they're essentially ignored. So for us, it has not been a good experience in North Dakota. If your state has the ability to fight Marsy's law, if it's coming, I would urge you to definitely do that. It's too late for us, and we're still trying to fight out what exactly it means. But it has not been a good experience here in North Dakota.
Thank you so much, Jackson, for just sharing and shining the light of how it's dealing, how you guys are handling it in North Dakota. And just to continue to reiterate, especially when you were talking about your use of depositions and how Marsy's law is impacting that, we are talking about a set of rights that are being applied at a time that, it hasn't even been determined that a crime occurred. We are talking about pretrial, and while, hampering the ability for the defense to mount an effective defense, and where the client is still presumed innocent. And so that is just really important to note. And even when you were talking about the use of restitution and it being linked to probation, it's another area that's very ripe for reform, the use of community supervision and a lot of parole and probation reforms. And so looking at our efforts to reform community supervision and how, if we're linking restitution being paid to your length on probation, how that's going to impact those state reforms. And I mentioned that because we actually have a panel discussion tomorrow at 4:00, which will be talking about parole and probation reform as well. I'm going to turn over to our next panelist, which is Laura Hessburg. She is the Public Policy Director for the Iowa Coalition Against Domestic Violence. And maybe at its face, it may seem, odd that she is joining this panel of advocates who are talking about Marsy's law and opposing Marsy's law, but I'm going to let her explain her organization's link to Marsy's law and why they have been on the side of opposing Marsy's law in Iowa as well. So Laura, you have the floor.
Thank you. Thank you very much. And it's a pleasure to be on this panel with these people in states I've just really admired your work. Has made it a lot easier in Iowa, and your input on this. And as you can tell in our statements, I've probably lifted heavily from op-eds in your state and stuff to fight this. It's been hard. Our agency is based in Des Moines. We're a statewide agency that represents local service providers. So our member programs provide crime victim services in every Iowa county. And so I think a lot of people think of us as providing just, hotline calls and an emergency shelter. We do a lot more. Our people, work 24/7, 365 days a year. And in addition to the crisis response, they support survivors in legal proceedings, but also significant time spent helping victims obtain housing, healthcare, access to services, school, jobs, basically any service that helps them rebuild their lives. And I go into detail about that because one thing that's been helpful in our efforts, it's, as you can imagine, like you guys, it's a very emotionally manipulated campaign, and it makes it hard to explain because on its face it sounds so bad, but it helps us when we say we don't speak for all crime victims, but based on basically several thousand years of combined experience serving victims we oppose Marsy's law, and we make it very clear that we support victims and we support victims' rights and we support elevating their voices, but we do not oppose Marsy's law. And every one of our member programs and the member programs of our sister coalition, the Sexual Assault Coalition, is publicly opposed to this. And I say that as if it's easy. It isn't easy, but their opposition is based on experience. It's still hard to have that discussion, but it's helped prepare them for that. Basically, we oppose Iowa law has, I think every state now has extensive victims' rights protections. And so we believe instead of amending the Constitution, it makes more sense to improve access to legal rights and comprehensive services, and that would more effectively meet the needs of all survivors. I mean, having constitutional rights doesn't address the comprehensive needs of victims, and it doesn't improve any access to the rights and services, and really the ability to find justice and healing during and long after any involvement in the criminal legal system. It takes money and people to do that, and I think that's what Marsy's law supporters are loath to admit. For example, a victim can't exercise her right to be heard in court if she can't afford a lawyer. She doesn't have a job that lets her have time off, to do that. Or, as has been brought up, if she's the one that stands accused because she was being strangled and she's, now is the defendant because she scratched the face and people showed up and arrested her instead of him. So, however, we make clear in many of the Constitution you comport with Marsy's law, it will cause harm. And as has been eloquently said, it undermines fundamental principles of justice and makes, it's particularly tone deaf in terms of the events of this summer and efforts at criminal legal system reform. It doesn't make sense to impact the justice system in that way. And I guess what's helpful when we've talked from a victim's perspective is just to, like, a lot of times people have different victims in mind. I think they everyone, crime victims suffer devastating loss, but the insensitivity and the indifference, that they experience, it's not limited to the criminal legal system. And one thing that was really important to our providers was it seems so unfair too. It only elevates the rights of the small number of survivors who seek justice in the criminal legal system. The vast majority of crime victims of any kind never set foot in a courtroom. And so most of the people we serve, the constitutional right for this doesn't apply to them. So certainly crime victims deserve rights, but they also deserve rights and support that beyond what the legal system is designed to do. And so I won't repeat, but we oppose for the same reasons about this assertion that victims deserve constitutional rights equal to the accused that has probably been the most difficult point to address, but that's why I've really relied on your states and what we've said, because I think clearly defendants' rights exist to protect innocent people from arrest, imprisonment, and death. They don't exist. It's not because the rights of the accused are more important than victims. It's just because they have a lot to lose. And I think the way we remind people is that the criminal legal system, it's not designed to mitigate the devastating impact of a crime. It's there to determine innocence and guilt. And the price of getting that wrong is pretty high. And so not only does getting it wrong, deprive someone of their liberty, but it means an offender remains free to harm others. And that's been helpful sometimes when we say that. Victims' rights serve a completely different purpose, and that's aimed at supporting recovery and not protection against government power. And so, as been said, when you throw out the notion of innocent until proven guilty, that harms everybody. And again, from a victim's point, reiterating that point, upholding these ideals of justice serve all victims. I mean, especially the victims we serve, the distinction between victims and defendants is not a bright line. So it's like often, basically many survivors of domestic violence are convicted of crimes. They've been, so they're convicted of crimes themselves. Either their criminal activity was a survival mechanism, or they were, arrested for a crime because they were defending themselves. And frequently, clearly the presumption of innocence is not experienced by a lot of domestic and sexual violence victims, but especially has been brought up communities of color. And so, the bias based on race, gender, immigration status, all those things, Marsy's law makes that worse. And, it's also too in Iowa, and I think a lot of states that when I've been reading about what the experience in other states, not only do we have law, but we also have a good idea of what victims need. Many states, Iowa did a statewide survey in 2016 out of the Attorney General's office, and it listed the host of things that victims identified they needed. And tops on the list, housing, transportation, employment assistance, healthcare, childcare, and yes, legal assistance, but that's a pretty comprehensive list that a constitutional amendment proposal can't address. So I guess, we can and should do better, and we have a good sense of how to do that. In the materials I sent, there's some good reports out there that talk about how survivors define success, and those are interesting reads, and I'll just shortly say, just reiterating the point that most victims of crime, and the ones we serve, but most victims never set foot in a courtroom. They need services outside of the courtroom, and I'm not dissing the courtroom. I didn't mean it that way. And then just you said to mention some advocacy tips that helped, and I just don't reinvent the wheel in these states, and what everyone said. Take it seriously. I mean, I appreciate the shout out, but the only reason we've been able to hold it at bay is because it has never gone to the floor for a vote. So everything you can do to get your allies lined up, and it's been 3 consecutive years now. We've fended it off, and it's been hard, but it really helps. And one thing early on that helped is, I think a lot of, and Senator Schickel will probably address this too, is just, I think a lot of early on, it sounds so appealing, and people think, oh, it's just a throwaway vote. And what I like to remind folks is, this isn't a vote on a resolution for Domestic Violence Awareness Month. This has significant consequences, and that helped. And even like initially, I think these arguments from supporters have gone now, because we did educate people, this argument, they sweep in and they say, Iowa, we actually don't have any constitutional provision. So we're one of the 15 states that it wouldn't amend our constitution. It would be anew. And they'll say, well, 34 states have this. Why don't, and legislators were like, well, why would you put, it's like, well, 34 states do not have Marsy's law. Marsy's law is very different and it was really important to show that to legislatures. That wasn't just a talking point. You can clearly see the difference in the the constitutional language in those states versus what Marsy's law does. It's, I guess the way, that helped. And again, it is just like that not only it helped also not to prepare our service agencies, but also, allied organizations. We often work with Interfaith Alliance and other organizations on other issues that support it, so prepare, your friends to talk about this too. And even candidates, it helps, that's one way of mitigating it before it gets to, a vote. And we reached out to law enforcement and county attorneys, and, it did help to nip it in the bud a little, not that it still wasn't hard. So I guess and we also came up with a 1-page list of okay, we don't think this is the best way to do it, but you guys are legislators. We have a list of things you could do this year. If you wanted to help victims, we have a list. You can do this, and that helped. And then also just some of the language, in one hearing, well, if you don't support Marsy's law, you don't support victims. And I think just don't be afraid of calling the bluff, is what I would say to folks trying to sort of, again, we just we don't speak to for all victims. No one can, but clearly our experience, our providers do this for a living. So you cannot say we don't support victims, and the equal rights thing, that's a hard one still, but, they don't say it as often, thanks to the work of the defense attorneys in giving us good language on that. And just the unfairness, what I meant. And also just the, one thing that came up too was the need for enforceable rights. And our lawyer friends, like you guys helped with that too. It's like, Well, I mean, the constitutional amendment's not how you fix that. You know, constitutional rights are no more self-enforcing than statutory rights. So it's easier to fix that through statute. And I think what really did, at least from the victim's perspective, help is you know, really talk about what victims need. You know, it's, I mean, and with stories about that. And then in the case of, you know, why we talk with a lot of the defense attorneys is that a lot of times those are victims of domestic violence. And so I'll stop there because I know we're running out of time. Like you said, we could talk about Marsy's Law all day.
No, thank you so much, Laura. I'm going to introduce our next panelist, and definitely very glad to have him. He actually hails from Kentucky, which, little known fact, actually was born in Kentucky, in Fort Knox, Kentucky, to military parents. So glad to have him representing Kentucky. It is State Senator John Schickel. He has had a 43-year career as a state senator, serving on the Judiciary Committee. He has served as a corrections administrator, law enforcement officer, and teacher. He has received numerous awards, including an award from the Innocence Project for his work on post-conviction DNA evidence. And I'm glad to have him on this panel because, one, he has worked with a lot of the advocates on the ground in Kentucky that we have worked with in imposing Marsy's Law, as well, including our state affiliate in the state ACLU out in Kentucky. He is, I will let him explain it, but he was like the lone no vote on one of the votes when Kentucky was dealing with it. In Kentucky, it's been interesting. I'm sure he can attest to. Their legislator had passed it twice. It went to the ballot. The voters approved it. It was challenged, declared unconstitutional, and it has come back again. So I'm sure it has been a long fight for them in Kentucky. But I will let him take the floor and tell us about his role and work with dealing with Marsy's Law in Kentucky.
Thank you, Monica. It's great to be here on the panel. And you're right, it has been a long fight, and the fight continues. It's going to be on the ballot, unfortunately, this November. In your introduction, you said I had been a state senator for many years. I've only been a state senator for 12 years. I'm actually a retired police officer. And that's what I did for a living before I did this. And so I think I bring a little bit different perspective to the panel. I get all the time, what is a retired police officer doing being so against Marsy's Law? This is actually my 4th year, I believe I've dealt with it. The very first year it was here, I actually supported it because I didn't realize how bad it was. When you first hear about it, you think, oh yeah, this is good, it's for victims' rights. Then I got looking into it, and I realized how harmful Marsy's Law is. And it's like Laura says, you know, this is so important. This isn't a resolution to support something. This is changing the Constitution. There's been a lot said and a lot covered, so I'm going to try to cover some of the things that haven't been covered. But I think that there's 2 things that I just, because it all boils down to this: the presumption of innocence and protection from the government, and protection from the awesome power of the government. That's what the whole thing boils down to. And I believe, probably unlike a lot of people on the panel, I believe in a robust criminal code. I believe in the death penalty. I believe in punishment. And that's why the presumption of innocence is so very, very important. And anything that erodes that, I'm against. Politically, we talk about ways to stop it. And that's what I wanted to cover, because this is probably the wrong thing to say to this panel, but one way you're not going to stop it politically is letting people know that defense attorneys are against it. You know, that is not going to stop it politically. But what is going to stop it politically is the use of victims advocates. And that's why it does my heart so much good to hear Laura speak in such an eloquent way, is why this is bad legislation. And that doesn't obviously mean we can't use defense attorneys to get our information, because I believe, you know, they serve a very important purpose. But the political reality of it is that to stop it politically, that's not the way you're going to do it. But the good news is many prosecutors are against this. They're many times afraid to say it, but they're against it. And the reason they're against it is, we all know that the prosecutor's first duty is not to prosecute. The prosecutor's first duty is to find the truth. And this hampers finding the truth. I believe it was Jerry that I believe it was Jerry that said that if someone who is not a victim and is insisting they are, and they confront a prosecutor and they want charges pushed forward, many times a timid prosecutor may do that under this. That's not the prosecutor's job. The prosecutor's job is to find the truth. It's interesting because the first year that I was against this, I was the lone no vote in the Senate. But then last year we had several more votes. You know, it still passed, but we had 5 or 6 people vote against it in the House and the Senate both. And I think there really was a feeling that that more and more people were realizing, once they had time to learn about it, that it wasn't a good thing. So my advice would be, for stopping it, is getting out there early. There's no question the finances of the opposition is just so overwhelming. It's very difficult. And that's why Iowa and Laura, I think, have the right recipe, is trying not to get out of committee. Unfortunately, in Kentucky, we had a bad situation in committee, and that wasn't possible, but that would be my advice.
Awesome. Thank you so much, Senator Schickel. I am going to, so definitely in the audience, submit your questions through the Q&A. I do want to bounce one off Laura and then let anyone else also chime in, though. As we see, so I guess it may have varied in some states. I know in your state, in Iowa, and I know in North Dakota, where the advocates had the support in opposing Marsy's law from their victims groups. Before the states that may have been dealing with it that don't, or states that say it hasn't come up yet, how best should they approach kind of working with their victim organizations to get them on board and helping them oppose Marsy's law?
Yeah, I do feel lucky, because I know even in some states that the coalitions or the victims organizations are even split, so it makes it hard. And I was thinking about that, so I don't know if I'm an expert, because we were lucky that we worked together on it, but I think it's sort of the silver lining of this moment in American history right now, not just the result of the summer, but before that, this move and seemingly pretty broad spectrum support for criminal justice reform. And so, especially after the summer, I know a lot of coalitions, victims organizations are really rethinking what they have done to contribute to mass incarceration, racial disparities, and maybe just sitting down with them again and saying, would you reconsider? There's some, and if I certainly don't know every single program director, but there's some states, feel free to contact me. We can give contacts in some of those coalitions. And because I think the common ground is just acknowledge the common value. The common value is support for victims. There's many ways up that tree, but even sometimes upon further conversation, there's Marsy's Law field team is everywhere. And we heard reports of a victim they had, got to go to one of these coffees, and she's sitting, thinking she's a supporter. She says, wait a minute, I have a felony conviction. This will harm me. So there's room there. And one thing that's helped us a little bit in that department, or what help is really push folks, whether in this case, if it's the victims, or just how do you see this actually supporting a victim? It's very hard, the Marsy's Law people cannot answer that question. How it specifically, how would this victim notification is something that comes up all the time. Iowa has victim notification system. So the problem, it's a resource problem. Not that, we have victim notification, it's a resource, sort of just making it so it's not a cut and dry issue. It's a nuanced issue, and allowing, acknowledging the shared value, and maybe there's different ways up the mountain, and we might not ultimately agree, but this would be very harmful.
Yes, thank you so much. I'm another question to pose, and maybe our two kind of defenders on the panel can answer. It comes from Arizona. So someone's asked, so in Arizona, we have a statute that forbids criminal defense lawyers and investigators from initiating contact with crime victims, including relatives of murder victims, which has had a big impact on criminal practice there in Arizona. We're under the impression that this is a unique provision across the country. The question is it unique, and what are other outlier provisions across the country?
Well, it's certainly not going to be unique under Marsy law, wherever that gets enacted. And, you know, what the way to have to challenge that is going to be, you know, I said that there's no express constitutional right to discovery that the Supreme Court has found, but there are due process rights. And particularly when it comes to exculpatory evidence, the Brady rule, where prosecutors are supposed to turn over evidence that could be exculpatory. But now, you know, if they don't know it, if the prosecutors don't know it, if even the police don't know it, because the alleged victim has refused, for instance, to allow them to go through their phone and see relevant information, then, you know, what's going to happen in those cases? Can you, I mean, ultimately, you will have to file a motion to try and get the judge to order the accuser to turn over whatever evidence they have or to submit to an interview, but it's going to be a real battle. And, you know, when it comes down to defendants' due process rights that aren't clearly spelled out with regard to pretrial discovery versus an express provision in Marsy's law, constitutional amendment that says they have a right to refuse depositions or interview requests. I don't know. I mean, it's going to be interesting how courts ultimately resolve that conflict.
It sounds like the Arizona provision, at least from North Dakota, is much different. We never had anything like that in our provisions prior to Marsy's law. But now that's essentially what Marsy's law does. If somebody wants to not cooperate and they don't want to provide evidence, Marsy's law allows them to do that. And what you'll often see is the prosecutors will make sure that they understand that it sounds like the defense attorney wants to depose you. By the way, you don't have to do that. You don't want to do that, do you? Okay, well, I'll file something saying they're not going to depose you. And it has impacted our ability to get that information.
Thank you. Before we wrap up and I give closing remarks, I just want to open the floor to the panelists if there's anything else that they just want to mention before we close in terms of any helpful tips that can be provided to advocates in states or even in advocates who may not be dealing with it this year, but maybe it pops up in their state next year.
Well, certainly we've talked about how it's important to try and educate the legislators and the public early. But, you know, I would also urge advocates in their own states to maybe talk to lawyers that do election law and have some expertise in how a ballot question must be framed. I mean, in Wisconsin, it was really misleading. I mean, you know, they condensed 16 new rights into one sentence that basically says, should victim rights be amended, added to essentially make them equivalent or, you know, no less important than defendants' rights while not impacting defendants' rights. Well, that's not at all what the amendment did. And one way to challenge it then is to, under election laws, to argue that the ballot questions were improper. So, you know, look at that. That approach has succeeded in a few other states as well.
That's how we got saved. Our Supreme Court ruled the ballot question was unconstitutional, and so that's why it's on the ballot again this year. So it's an excellent point.
I just want to thank this esteemed panel. I'm very excited to have been able to bring everyone together and to share this kind of conversation on Marsy's law. Again, obviously in states that have either been successful at fighting against it or have been dealing with the adoption of it. But even so for advocates in states that it may have not come up yet, but I think a lot of what our panelists have shared and emphasized is the need to get ahead of it early. So definitely wanting to kind of put it on your radar for you and in your state. And then definitely just reach out to us, you know, keep us engaged. You can reach out to us at NACDL. We can connect you to these wonderful panelists. We can connect you with other advocates in states that have been dealing with it. We've been kind of following this as it's been moving since 2017. And we'll continue to do so because it's greatly going to impact, again, a lot of the reforms that we are talking about during this conference and that are being championed around the country. You know, we talk about bail reform, discovery reform, reforms to community supervision. It's going to impact a lot of the reforms that you guys are probably working on and championing, but if it comes to your state, it is going to undermine those reforms. So again, reach out to us, share with us your stories. If you are in the defense and you are in a state that is dealing with Marsy's Law and you have another something to share about how it's impacting your practice, please share it with us. You can email it to scjn@nacdl.org. We want to hear from you. A lot of times we get asked by advocates in states about like what's going on in other states, like in states that have dealt with this, and being able to synthesize your stories, articles and resources that are out there is very helpful for those advocates. So share with us your stories. We can use it to help advocates in states that are dealing with it in Iowa and other states who are still fighting against it to really strengthen their arguments. Again, thank you so much to this panel.